is in comparison to the targets?
Well, I see the clock has struck 2 here, so there's a lot of material, so I think I'm going to get started if no one minds. Hope everyone can see me on the webinar. Welcome to the Ascend Hub webinar series. Today we're going to be discussing key considerations for IP patent prosecution and licensing. Happy Halloween to everybody. My name is Jeff Peterson. I'm an attorney with the law firm of Michael Best and Friedrich. I was a molecular biologist before I went to law school. I do patent prosecution work as well as chair our firm's licensing and technology transactions practice. I work with over 30 universities, kind of helping them protecting and licensing their technology, as well as working with a lot of new ventures, faculty startups, trying to commercialize the technology and working through their licensing issues as well. Because it is Halloween, I decided to dress up as attorney with a head cold. So if I sneeze or cough or anything, I'm just really committing to the role today. So I apologize for that in advance. So I know that the last month's presentation was sort of an IP overview. Today I'm going to talk a little bit more in depth about patenting, the patenting process, how that works. And then I'll try to get through that in a timely fashion. At the end, I'm going to talk in general, sort of overall considerations with the licensing. What do you do with some of these patents? Certainly if you're an educational institution rather than simply a commercial entity, you may want to license these patents because universities generally don't make and sell products. And so they'll generate revenue by licensing. So we'll talk a little bit about licensing as well. But we'll start off with patents. So what is a patent? Well, it's a grant by some sort of federal government or national government for the right to exclude others from practicing a claimed invention for a limited period of time. It's a limited monopoly. The patent does not give you the right to practice your invention. It gives you the right to exclude others from practicing your invention. Sometimes that's a concept that people misconstrue. Oh, I get a patent. How can this person be suing me for infringement? I've got the patent on this technology. So you can think about it in a very sort of macro way of, if you've got a patent on an overall design for a motorcycle, but somebody has a specific patent on the brakes, you may be able to get a patent on that overall design and how everything connects together. That doesn't mean you can necessarily practice that invention without maybe infringing someone else's intellectual property rights to get a license for those components. Well, what do you need to get a patent? Well, you need to meet the criteria for patentability, which we'll discuss. And of course, the intention of why the government gives this limited monopoly is to promote and encourage innovation and public disclosures of advances. That's the quid pro quo. That's why people don't necessarily keep things as a trade secret. We'll give you this limited monopoly as long as you tell us everything about your invention in this patent application. So like I said, it's a negative right. You can exclude others from practicing. If you can get a dominant patent, a broad patent that covers a lot of aspects of the field, think, again, the overall motorcycle, that may cover subsequently developed products that themselves also have new patented features. So you can have a broad patent that covers a great deal of subject matter and smaller patents within that coverage that capture discrete other protectable elements inside that broad protection. It does have a limited term. That term is 20 years from the first filing date for the invention. So if that could be if you have subsequent continuation patents, which we'll talk about later, and they all claim back to that first patent, that 20-year runs from the first filed application. Before they had an earlier patent term, I would say 89, I'm trying to remember when the patent terms changed. The term ran from the issuance date. So once it issued, your term ran from that date. But there were abuses as people were kind of stringing things along, keeping things from issuing to kind of extend that term. Now it runs from the filing date, you get to 20 years. There are ways to get extensions on that time if there are delays at the patent.
Yep. Okay.
All right. Well, I'm not quite sure where we lost you, but I'll go very quickly through some of the slides here before we had some technical difficulties. Again, patents are granted by governments to give you a limited monopoly in return for full disclosure and meeting various patent criteria under the law of that particular jurisdiction. The intention is to promote progress by encouraging innovation and full disclosure of the advances in the patent application. Patents provide right to exclude others from practicing the claim invention. Does not give you the right to practice it itself if somebody else has their own proprietary rights around that technology. You can have patents have different scopes of coverage. You could have very broad coverage. You could have very specifically or more narrow coverage, even inside a patent itself. You could have broad claims. You could have narrow claims. You could also have multiple patents, such as one is a dominant patent covering the principal ideas around the invention and subsequent other filings, narrowing and refining improvements on that invention that are narrow in scope, but also protect the invention. Patents have limited terms. Generally, they start and end at 20 years from the earliest date of filing, your date of priority. People can mark things patent pending instead of marking with a patent number. Traditionally, there's no rights with that, but there are some potential rights with pre-grant publication if you put people on notice of that patent application and eventually issues similar to what that published application looks like. There are different types of patents. You can have a utility patent, which is what we normally think of, a standard patent protecting the actual concept, the innovation, the execution, the utility behind your application, whether it's a device, a process, a method of use, software, a method of doing business. You can have something called a provisional patent application, which is really just a placeholder. You can file something with a little bit more informal nature of what's disclosed, though the legal requirements for what is supported by that disclosure is the same for both the provisional and the formal. When you file that provisional, it just buys you a year. Within a year, you're going to have to file both any U.S. or foreign applications, or something called a PCT, which we'll discuss later, within that 1 year time frame. If you don't, that provisional will just die and it will never mature to a patent. It's just a placeholder for you to file that next patent application. You can have a design patent, which presents just the ornamental features of an item, whether it's the design for a shoe or a cell phone or something of that nature. And there's also plant patents, which cover different types of plant varietals. Patents are a little bit different than trade secrets. With a patent, you're going to get that limited monopoly. You have to go through registration. You have to disclose everything. Trade secrets, you have an unlimited term as long as you keep it a secret. It's really there to protect against somebody getting your access to your formulations or other trade secret information inappropriately, either an employee that leaves and takes it with them, or someone hacks into your system. You may have a cause of action against that person if they get access to your trade secret inappropriately, but you would not have a cause of action if somebody simply reverse engineers your technology by accessing publicly available technology, say the product that you sell in the market. They figure it out, or they just figure it out by themselves without even accessing what you're doing. A patent would protect against that as long as it's covered by the patent. Whether they got it from you or not, your patent would cover it. Trade secrets don't work that way. Copyright is somewhat similar. They have to actually access what you have. It's a little bit thinner protection. It's easy to attain. As soon as you create something, you get a copyright. I know you guys discussed this in last month's presentation, so I'll go through it quickly. As soon as you fix something in a tangible medium of expression, write code, write down what you want, write on a piece of paper, you now essentially have a copyright in the expression of that idea. It's got a longer duration. Trademarks, again, I know you covered them last week. It's really identifying a word or a sound even, colors. Owens Corning has a registration on pink for fiberglass that identifies the source of the good. So when you see that word, you see that logo, you see brown on a delivery truck driving down the street, you know where the source of that good or service is coming from by way of the trademark. You can also register trademarks with the United States Patent and Trademark Office as well, which we won't talk about in this presentation. So should you file a patent application? Well, one of the things you need to look at, even if you're a university, is eventually, what's the role of that patent going to be in the eventual company that's going to commercialize that patent, whether by way of owning the patent or they could be a licensee of the patent. What protection is that going to give them in the overall source of the commercialization of the technology? Is it going to be a broad patent? Is it going to provide sort of significant coverage in the industry? Are there multiple patents already? Is it going to be fairly narrow in scope, and that you're going after a specific embodiment that you're trying to sell? Trying to identify what is patentable out of your technology is an exercise that you should go through very early on to get a sense of, okay, I've got this idea. What am I likely to get out of it? And what's the commercial value of it? Not only what can I get a patent on it, but what would that look like in the industry? What is the space that we want to fill? And then what's the value of that to a company? Is it going to be, really stake out a huge market for a potential company, or is it going to be a companion protection, say for an existing drug or a medical device that's going to help on the delivery of the drug? Where does this technology fit in? And what are the other alternatives? Is this a formulation, or maybe my invention is a process of doing something? Maybe I'm better off keeping that as a trade secret without disclosing it there, because now I've got to tell everybody how to do it. I may not be able to get protection for the full scope of it. Nobody's ever really going to be able to reverse engineer it. Maybe trade secret's the way to go, because I think I can get some value out of that before somebody could possibly independently develop it. Well, what's patentable subject matter? And this is a very hot topic right now, especially for software and life sciences. No laws of nature, no abstract ideas, no products of nature. Now, things that are touched by the hand of man, and historically, since the 80s, we've been able to patent that. So if you genetically engineer something, if you purify something, if you have something else that's part of what you're claiming, even though it may be part of nature, historically that's something that's going to pass that test. It's patentable subject matter. Generally, products, compositions of matter, processes, etc., as long as it doesn't fall with one of these three exceptions, are patentable subject matter. Right now, there's been a lot of pushback the last couple of years on the kind of this no ideas, laws of nature. How far does that go? Certainly in life sciences, a lot of diagnostic things have been now adjudicated to be not patentable subject matter. If you're just identifying something, a law of nature, a biomarker that's out there, and you just run an ordinary test to determine if somebody has that biomarker, and that's your way of testing cancer, that may just be unpatentable subject matter. All you've done is identified something, you run a standard test to do it. It's not so much that it's not novel or unobvious, which we'll get to. They're now saying that just may not be patentable subject matter. Same thing with software right now. If you just kind of have a simple abstract idea of how to do something, and I'm just going to do it with a computer without showing what the benefit is, that just may be unpatentable subject matter. It's just too abstract to get patent protection on. So for certain life sciences and software things, that is an inquiry you're going to have with your patent agent or counsel to kind of drill in what's the invention here, and is this in fact patentable. The second hurdle are the other two hurdles. It's got to be novel and unobvious to one of ordinary skill in the art. Novel means that when you have your invention, describe what it is and the claims of your application. Has it ever been done before? And that date is that first date that you filed the application. That's your filing date. That's what they're going to determine novelty on. So they call it prior art. Everything that's come before, any publication, disclosure, essentially worldwide, including your own, with certain exceptions, that come before the date that you file your application, is what your novelty is going to be based on. And how you claim it is no one ever done exactly how I'm claiming it before my filing date. The second piece is non-obvious to one of ordinary skill in the art, which is usually the harder one to come over with, which is, yeah, no one's done it exactly the way I'm claiming, but what I'm doing is not that unobvious to one of ordinary skill in the art. It's a combination of kind of what's out there already. I kind of put it together, and one of skill in the art would be motivated or readily think that I can make that combination. If it meets the characteristics, it may be considered non-obvious and unpatentable. Another drawback to consider when you're filing patents is cost. Things like trade secrets, all you got to do is keep it a trade secret and put in protections in place with your organization to do that. Copyrights you create when you do it automatically. Patents, you got to prepare and file it and prosecute it at the USPTO. So you got to figure out how big is the application, how long is it going to take to put together, is it complex, is it simple? Not only do I have to file it, I've got to prosecute it. We'll talk a little bit about that. I've got to maintain it. You have to pay fees once it issues to keep it going. So if you're going to be a new startup and you're going to be paying the expenses, you need to look at the cost life cycle of that patent application, filing to prosecution to maintenance, and then possibly even enforcement, and what the cost would look like around that. This is probably the big one that everyone needs to pay attention to as an inventor, is that your own actions can bar patentability. And the big one you always hear about is public disclosures. I've disclosed my invention. I've used it in public, even if nobody saw it. I published a paper. I went to a conference and I put up my poster and discussed it. All those acts would be considered a public disclosure. When you have a public disclosure in most jurisdictions, that could bar your ability to get a patent on that subject matter outright. Some jurisdictions, like the United States, give you a grace period for your own disclosure. You have 12 months from your own disclosure in the United States for you to get to the patent office and file something to avoid your own disclosures being a bar date in the United States. That doesn't necessarily be true in other jurisdictions if you want to file there. So generally what you want to do is make sure you have something on file before you have a public disclosure. That's kind of where those provisional applications come. I got to get something on file quickly because I know I'm going to have this disclosure. I don't want to have a bar date pop up. We are now a first to file country in the United States since 2013, which is the first person that gets to the patent office and files it with that date, even if they weren't the first person to invent. If they've got the filing date and you come in later, you will prevail because you filed first. Historically, the United States has been a first to invent country, which is the first person to invent, even if they filed later. If they can prove that they invented it first, if you got in a battle with somebody else's patent and prior art at the USPTO, you could swear behind it. If you're filing, generally speaking, an application after 2013, you're not able to do that anymore. We are a first to file country. There are exceptions if you're filing some sort of continuation of an earlier filed application where you can still have access to the old law, this sort of transitional period. That's going to go every year. We get further and further away from that. It's still out there, so you may hear that come up. But generally speaking, the concept of swearing back or swearing behind a piece of prior art or proving invention, it's still going to go on for some transitory things, but mostly that's going away. It's first to the patent office wins. This talks a little bit more of that, the date of invention timeline. Historically, it was conception, due diligence, reduction to practice. That's what you have to prove that you invented it first. So if you're still in a battle of an earlier application showing that you were the first to invent, that's what you'd have to show that chain. Conception, due diligence, that you kept on working after conception, and you reduced it to practice before the other party. So how do I avoid public disclosures? Well, one of the things you can do is obviously get something on file before you have a public disclosure. Well, what if I'm a new startup and I want to talk to people? Are you interested in this and not? I want to share this with you. I don't want that to be public. You're going to want a non-disclosure agreement, either with another party or your employees, to make sure the stuff they're working on is kept in confidence. And make sure that you have those in place with those potential investors. Again, get something on file before you have a trade show, publish an article, go to a meeting. Use tools to encourage documentation of your inventive efforts. This was a bigger thing when you had to show dates of inventorship. It's still a good idea to do to show that you are the ones that created it and what your timeline is. So use inventor notebooks, which I'm sure you're all used to using. Keep it written down. Make sure you're dating things. Use invention disclosure forms. Again, don't really rely on that 1 year grace period unless you have to. Plan accordingly. Try to make sure that you've got something on file if you need to avoid that. The other thing to be in mind of, which I should talk a little bit about here too, there's a difference between public disclosure and on sale, which we'll talk a little bit later. If you offer for sale for something, even under an NDA, that's a whole different bar you have to worry about, which is you can't offer a product that embodies the invention or even offer the rights to sell the invention before you have something on file. You get that same 1 year grace period, but an NDA won't save you from that, a non-disclosure agreement. Even with a non-disclosure agreement, if you have an offer for sale, that's a potential bar. So what must a patent application include? You have to have a full written description of the invention, including how to make it, how to use it, and the best mode of how to make it and how to use it. You can't you could make it this way, but here's really the best way, and I'm not going to disclose that. No, you got to put everything in the patent application. You need at least one claim at the end of a patent application, which is kind of the property rights that you're claiming. I claim a stool comprising a flat planar base having a top side, a bottom side, with at least 3 legs connected to said bottom side. That's your claim for a stool. So if I have a stool with 4 legs that has at least 3 legs, it's got a top and a bottom, didn't see if it's round or it's square. You kind of have to think about on a broad scale, what does that look like? That's your claim on a very fundamental basis. Now you can have a broad claim, an independent claim, much like that stool example. And then the next, I could have a dependent claim, the stool of claim 1, wherein said flat planar base is a rectangle. So I've got one broad claim accompanying the broad universe of stools, and one dependent claim, which is smaller, it just has stools with a rectangular base. And then you could have multiple dependent claims where it goes back. I claim something both 2 and 3, where I've got the broad stool, the stool with the rectangular base, and my multiple kind of claim is the stool is made out of plastic. So it could be either one of those made out of plastic. We have a question.
Are those dependents inside of the same application or separate applications?
Same application. It's kind of a claiming structure. So if you look at a patent left claim 1, then claim 2 would be the stool of claim 1 further comprising. Think of it as a nesting, like a nesting Russian dolls. It's a subset of the longer ones, and it goes down and down and down. And then drawings, if they're necessary. Patents will have drawings if you need to kind of explain the invention. What else should the application include? Usually you have a brief description of the state of technology prior to the invention. And here's what the state of the technology was. Here's what we're trying to do. Here's the improvement. Usually you'll have examples or exemplars of different ways to practice it. Here's a way we can do it. If it's usually for pharmaceuticals or biotech, you can have, well, here's all my experience. Here's how you make it. Here's different ways to use it. Here's the therapeutic value of using it. Here's how this compound works versus this compound. Working examples are not required, but usually you place them in. They could be actual experiments you've done. They could be prophetic. You'll see a lot of prophetic ones in drug applications because you might not have gone into clinical trials left. You write up the clinical trial that you're planning on doing, and you indicate here's what we're expecting to happen. And then again, alternate embodiments of the invention and descriptions of the various uses of the invention. You have to list the inventors on the application. This is not just a question of who's the inventor. It's a legal determination. You don't necessarily have a choice of who you're going to list as the inventor on a patent application. If the individual contributes to the concept of the claim invention, they have to be listed as an inventor on the patent application. If it is incorrect and it was done in a deceptive manner, that you wanted to keep somebody off, or I'm the head of the company, I want to be in all our patents, whether you and you knew very well that you weren't an inventor and you put it on, that can invalidate the patent. You should work with legal counsel to make sure you're determining inventorship correctly, because it is a legal question and it is based on the claims. And this is important because inventorship determines ownership. If you're an inventor, you're originally the owner of that patent. You may have obligations by way of your employment agreement or agreements you have with your lab that says anything that you invent you're going to assign to them, but you're originally the owner of that patent. So if you have 5 inventors on it, they each own the entire rights of that application, barring their other obligation. So if you're starting up a new co as a new venture startup, and you bring on some employees and you don't have an agreement with them as an employee that you own what they create and they end up being a inventor on your patent, you now have somebody that owns a patent for your company, and you're going to have to figure out a way to get that ownership from that inventor. The patent examination process, it's long. It generally runs about 3 years, often longer. After you file an application, a formal utility application, not the provisional, no examination happens with the provisional. It just sits in a drawer until you file the formal one. Usually it's about 1 to 2 years. An examiner will pick up that application and start examining it. You can fast track it and get the whole thing done within about a year. You have to pay a big fee to the USPTO, and you have to jump through a bunch of other hoops. But it can be done. You get a patent examiner. The examiner fills the role of both the public advocate examining it and the judge. He makes the determination. It could be somebody who's been doing this forever. It could be somebody right out of the gate. It's kind of the luck of the draw. We're lucky now, comparatively when I start now, you can go to websites and there's people that sort of accumulate data on examiner statistics. So you can see, well, what's this examiner's allowance rate? You know, some examiners will allow 60, 70% of the cases. Occasionally you get an examiner that allows 22% of his cases and just rejects everything that comes back. It's like getting a good judge or a bad judge. There's challenges with working with examiners, and there's ways you can appeal and do other things to get it out of there. But you do need to be cognizant of working with the examiner at the patent office. And essentially what you do during prosecution is you look at all those claims, the property rights. The examiner looks at novelty, non-obvious, subject matter patentability. We'll come back, give you a report. I think claims, out of the 20 claims that you filed, claims 1 through 5 are rejected, claims 6 through 20 are allowed. And if you don't agree with his thoughts on rejection, you go back and forth and essentially argue with the examiner on what claims are allowable. The examiner is going to tell you, I don't think it's novel, I don't think it's obvious, I think the claim's indefinite, it's not clear what you're claiming. You either have to argue with the examiner and tell them why he's wrong under the law, or you could amend the claims. Okay, you're right, this claim's a little too broad, I wasn't aware of this piece of prior art. But if I narrow it, if I change that claim, so now that stool it's not made out of plastic, it's made out of stone. But no one's done that before, so you know, I've now narrowed the scope of my claim. It's not much narrower, but maybe I can get around the prior art and the examiner's concerns that way. So that's kind of how patent prosecution works. You're going back and forth, you're making your arguments, you're making your amendments to try to convince the examiner that the claims are in fact allowable under the law. If you don't get everything that you want out of an application, and sometimes that means because the examiner thinks there's too many inventions in your application. You know, I've got a stool, a method of making a stool, a method of using a stool in all my claims. The examiner says, pick one. That's 3 inventions. So I'll let you pick one invention for that application and that fee that you paid. So I'm just going to, you get the stool. If you want a method of making the stool, that's a separate application. I understand that you put it all in this one application, but you have to refile that. That could be something called a divisional application. So now I'm entitled to that priority date, but I got to file a whole new application, and the examination process starts all over again. Sometimes the examiner will say, well, I'll give you claims 1 through 5, but not 6 through 20. And you say, you know what? I'll take claims 1 through 5 right now. I want it. I want to get it issued. I'll cancel claims 6 through 20. Give me claims 1 through 5. I'll file something called a continuation application, which is I take the whole application and just file it all over again. I get the benefit of that early filing date. Even though I'm filing it again as a continuation application, it goes back to the parent application. I basically just give them another fee, and now I'm going to argue about claims 6 through 20 and convince you or amend them that I can get those allowed. But I'm not going to do that in the first application. I'm going to do this in this continuation application. That's one way of doing it. You can also do something called an RCE, or request for continued examination. Let's say the examiner makes up his mind. I do some amendments. The examiner comes back. I don't agree with you. I'll make your application final, which is you can't make any more amendments. You're done. I can reopen that and have them consider new amendments by filing an RCE and paying them more money. There's not much you'll find that you can keep this process going fairly long through different avenues of RCEs, continuations, as long as you're willing to pay the government for the benefit of doing it. They'll figure out a way to get money from you one way or another to keep this snowball rolling downhill, but there are procedures you have to go through to do that. You can interview with the examiner, both in person, out at the U.S. Patent Office if they're working there. Historically, now they're kind of spread out throughout the country, or by telephone, which is usually the more common, to get in front of them, explain your issues, explain what's going on. If you do have a rejection, you can appeal it, which we'll discuss later. The other obligation you have, which you'll hear about, is Rule 56, or your duty to disclosure. There's something called an information disclosure statement. Throughout the entire process, from the moment you file the application, you as an inventor have an obligation to tell the Patent Office any piece of art, prior art, publication, reference that you're aware of that affects the patentability of your invention. So if you're walking down the street and say, oh my God, that's my invention. I saw that right there. And you talk to the person in the store, oh, we've been selling that for 5 years. You got to tell the Patent Office that. Or if you come across an article or you come across a reference that predates yours, you have to tell the Patent Office that. If it turns out you intentionally did not disclose that, you could lose the patent. It'll be invalid for not meeting your duty to disclose. Cost, it's relatively costly to put together a patent. Could be $10,000 to $20,000 depending on how complex it is. If it's really simple mechanical, it could be 5 to 6. And that's the cost of just preparing and filing it. You have to pay both, your legal counsel or your patent agent who's licensed to practice in front of the office. You can actually go pro se and do it yourself. I wouldn't recommend it without knowing what all the laws and procedures are, but technically they'll accept an application that you file yourself. I've never seen that work well, by the way. As of last week, I had somebody who filed himself, came to my office. Oh, don't worry, I filed a provisional. And he gave me a paragraph and a flow chart. That's what I filed. And we got to formalize this next week. That can't be that hard, can it? And it was, but that's why you should talk to somebody. And then there's patent office fees. These fees, generally, you're looking about 4 to 5 through grant. They're going up continually. This is United States fees. It's more expensive in Europe and other countries as well. And also, if you're thinking about filing foreign, you have to remember as well, you may also be paying larger fees overseas. You also may be paying to have somebody translate your highly technical scientific document. And until you've seen what a translation fee looks like from a pharmaceutical application into Chinese, you'd be stunned. It's expensive, especially because now you need to get it translated for each country I'm going into. It could be a 30, 40 technical page technical document. It gets very expensive very quickly to file foreign. Small entity fees, if you are under 500 employees, you get a discount. You get a 50% discount of what those fees are. Though if you license it to a larger entity, that goes away because essentially the person that's getting the benefit of it is not a regular entity or a small entity. If you're a university in certain types of aspects, you can get even lower under this micro entity, but we won't really get into that. There's again tricks and risks with that if you're licensing it as well, but you could get it down as low as a 75% discount on your fees. We talked a little bit about this before. I think that it may have been before we lost our technical feed. There is something called patent term adjustment. Normally you get those 20 years. If there's a PTO delay or there's something that is slowing down the process because your term runs from you filing it, they'll add time on the back of it. If you take extensions along the way, they'll chop time off, not of the 20 years, that's set in stone, but of the extensions that you could get. So let's say you were entitled to a 6-month extension and you took a 3-month extension of time, they're only going to give you 3 months that they were normally give you 6 because you took 3 as well, but you'll always get that 20. If you have a problem with the patent, you don't get the ruling you want from your examiner, you can take the Patent Trial Appeal Board. You can appeal after a final rejection. It's an ex-party process between you and the patent office. And then you appeal, they get to apply, you can have an appeal conference with the examiner. That makes for a long pendency. The appeal process can take years. So you think it's long going through the regular patent process, now you get in front of the appeals office, that can go on and on and on. Before, I mentioned when we were a first to invent country, we have interferences. That interference process is still there for older applications. That's the process if you're going to get into a dispute with another party that filed a patent application and you're going to argue about who invented it first. That's what an interference is. They're still out there. You can still do them. But again, anything after, for the most part, anything filed after 2013, that's really not going to come up that much. You can also appeal things to the federal circuit and the district court as well. If you don't like your decision from the PTAB, the Patent Trial Appeal Board, you can take that to a court, and then you can take that up to the federal district court and appeals court as well. Patents are territorial. You get a U.S. patent, you get protection in the United States. You don't get foreign protection. Again, you still have a deadline to file foreign, much like you have to file in the United States. So if you file a utility application in the United States, you got 12 months to file foreign. From whenever your first filing is. If your first filing is a provisional, you got 12 months to file your foreign on that as well. There's something called a Patent Cooperation Treaty, which various countries are a member of, but not all countries. But it's most of the commercial countries in the world. If you file a PCT application, you're preserving your rights in all the PCT member countries. to eventually have the opportunity to go into those countries. So the normal thing you'll see a lot, especially with universities, they'll file a provisional. 12 months later, they'll file a PCT application, of which the U.S. is a member. You now have one application that just preserved your foreign filing rights in all the PCT countries. Or else on that 12-month date, you would have to decide what countries you want to go into and pay for the filings on that 12-month date, which is, okay, I want to go into Europe, China, Japan, India, Russia, the United States. Now I got to pony up and pay all the money for those 6 countries versus just filing one PCT application. PCT application gets examined by the PCT receiving office. It never issues as a patent. It just gets examined. We think it meets these international standards of patentability under the PCT. And then at 30 months from your earliest filing date, so essentially you've got another 18 months to get you out to your 30, you've got to file what they call a national stage application. So now it's essentially the same thing. Now I'm going to go into China, Russia, India, Japan, and you have to file separate applications, each one of those countries coming off of the PCT. The PCT just stretches it out another 30 months. Or no, excuse me, a total of 30 months from the first filing. So you have 12 months to file the PCT, then 30 months from that first PCT, if you file the PCT, to go national phase. Think of it about just now, it's just an extension. I get more time, but that may be more time to find a licensee to see if the technology is actually commercializable, what the value of that technology is before you write those big checks and start down the process of now prosecuting applications in multiple countries. Because it's not just the expense of having the baby, of filing the application. You got to raise the baby. You got to pay that. Now you're paying my U.S. Patent Counsel and my Japanese Patent Counsel, who's licensed to practice in Japan, and the translations and the fees and the arguments back and forth. It's very expensive very, very quickly. And most major commercial countries are part of the PCT, but not all. You always need to check if there's a specific market you want to go into and they're not a PCT member, that PCT is not going to cover it. You need to file foreign within 12 months. Again, we talked a lot about this before. If you don't go into the PCT where you get that 30-month full extension, you just got your normal 12 months and you can file directly. So, I don't need to go in the PCT. All I want is US and Canada. There's no sense in going through all that process. So I file my provisional application. 12 months later, I file in Canada and the United States. There are regional patents that cover multiple countries. The most normal one that people have heard of is the European patent. You can get an EP patent that has coverage for various EP patenting states that have signed up to be part of the EP patent. At the end of that process, when you get the EP patent, then at the end you elect which EP countries do I want to make my European patent be enforceable in. And surprise, surprise, depending on which countries you ask for, they all come out with their hand out to pay for the privilege of activating that European patent in that specific jurisdiction. And so even though you can have a European patent, that European patent may not protect all the countries in Europe, depending on what the patentee decided to pay for and elect at the time. So it's important to kind of consider what the commercial path of your invention. Where is it going to be made? What's the market? Do I have absolute novelty in these jurisdictions that I'm looking at? It's best to decide this as early as possible so you can plan your patent strategy. You can't correct patents by way of a certificate of correction if there's something wrong with it, if it's a typo or something like that. If it's a bigger error, you do need to go through a reissue process to correct an error. If you overclaimed, underclaimed, if you underclaimed and actually want to expand the scope of the claims, there's a window to do that. You have 2 years to do that. But once you reopen a patent under reissue, you're back open. You've given up your patent to re-examine it. They could reject the whole thing, and you could lose the patent. So think about reissues very carefully. There's something, re-examination, where if somebody else wants your patent re-examined because they think that you shouldn't have gotten the patent, hey, the examiner never considered this piece of prior art. There's ways to do that either through post-grant review, inter-parties review. This is a lot more information than you need to know. Other than that, if you see a patent out there that doesn't look like it should be issued, there's a way to have almost a inter-party trial-like experience in front of the PTAB where you have an adverse party that's no longer just the examiner, it's another party. It could be another commercial party, a competitor party, and you're going to argue about should this patent have been allowed or not, and have it re-examined or reviewed. Once you get it issued, you can have maintenance fees, so you have to keep on paying fees to keep this going as well. And supplemental examination actually should have been on the other slide, the other ways to kind of submit relevant information to your application. Again, there's different things that you may have to file with different applications. Software and computer-related inventions, or something like those business method applications, can kind of blend into the software ones. Again, patent-eligible subject matter, we talked a little bit about this earlier. Very tricky right now for both life sciences and software applications. Does it meet those laws of nature, abstract idea? Biotechnology, you may actually have to provide a biological deposit. You may have to add a sequence listing for sequences that you're claiming. It's just more sort of formal obligations that you need to put in these applications when you move forward. So what do we do with these things? Well, certainly if you're a company, you have a patent. Now you have the right to exclude others. So you could just keep that owned by the company. We're not going to license it out. We're going to retain the rights to exclude others. And then if someone of our competitor enters in the marketplace, we have the rights to either sue them or force them to take a license. Universities generally are owning the patent. Sometimes they need to elect ownership under BIDOL if there's federal funding that was involved with the creation of it. But they can license the rights, even exclusively, back to a company. So most faculty startups tend to look like that. It was developed at the university owns the technology, they license it to the faculty startup or to a larger entity, which means they own the patent and they grant you the rights that they would have as an owner to the patent, other than they retain ownership, in return for some sort of consideration. So if you are a company and you're interested in taking a licensee, you're kind of doing the same thing that the patentee was doing, is what do I need this technology for? Is it going to improve the functionality of my products, my manufacturing process? Is this a whole new way for me to do business? Usually if it's a faculty startup, it's the whole purpose of this business is to commercialize this technology. So it's a new technological platform that's going to kind of build off the new R&D and other things we're going to do to take this nascent technology, take it in the marketplace, but we need these rights. So you need to think about, okay, what rights am I getting with this, much like you would when you're filing the patent. Another thing to think about is, what do I need this patent rights for? Is it to exclude others, or is it freedom to operate? Because I don't have a business unless I have the rights to do this. Because either the university or somebody else is going to exclude me from doing this because the patent gives them the right to exclude me. So I just need the rights to practice it. I may not even want to enforce it. I could have non-exclusive rights, which means other people can use it too. I just need the rights to this to practice. When you're thinking about licensing, both parties need to evaluate each other. So what's the stage of technology development? What do we need to do to take this technology and take it into the marketplace? Is the patent I'm giving you have full value that you can turn this into a commercial project, or product tomorrow? Or is it going to take a certain amount of R&D and development to do that? That has a sense of what the value of that technology could be. Who are the parties involved? If I'm the licensor and I'm licensing it to somebody else, who are their affiliates? Who am I giving rights to? Am I just giving rights to this individual or all their subsidiary companies? And what does that mean? You want to make sure, if you're the licensee, that the licensor actually owns the technology they're licensing. We talked a little bit earlier about the inventorship issue, where there's multiple inventors. Are there inventors that didn't assign their rights to the company, so they don't actually own all the rights in the patent? I could check the title of the patent at the USPTO if they recorded it. Did they assign it improperly? Are there liens on the patent? Does somebody else have rights in the patent that could affect my rights as the licensee? What's the status of role of the key individuals of the parties? So if I'm the licensee, do I need access to the person that created this patent and their knowledge? It's not just the patent. Somebody's got to show me how to do this. Or am I the one that has that knowledge as a faculty startup? That may be the same thing. That's not a consideration. The financial status of the parties. Usually for a university, this is a big consideration with their licensees, which is universities have different incentives to license than a company to company will. Companies are generally interested in obviously generating revenue, generating profits. Universities have different considerations when they do a license. They may want to grow jobs in the community. They may want to retain faculty by granting that faculty member a license to do their startup. They may simply just want to make sure this technology gets out there and in the public and benefiting the public. So they'll look at the considerations of who am I licensing it to? What's their financial status? Does this licensee have the ability to actually start the company and raise capital and move forward? Or do they not think that they don't have a business plan? They really have no money behind them. I can give them this license, but I just don't think it's going to go anywhere. And even with the other considerations, it's something you want to take a look at. Do they have the ability to commercialize the invention? Do they have the commitment to the license? What do they plan to do with it? Do they have a plan? Do they know where they're going to go with the technology? And what type of support, training, and know-how and access to the confidential information that the patent owner has do both parties need? You'll often get this sometimes with sponsored research at a university, where, okay, I get an option to license the technology, but I don't just need the patent, I need kind of the know-how, the training, et cetera. Is that going to work its way into my license agreement? If you're the licensee, you got to make sure you're getting all the assets that you need. Yeah, we talked about before, you could have a dominant patent and smaller patents that cover different items of the technology. Are you in fact getting all the assets you need to actually commercialize your invention? Is it scope of coverage that you need? Or are there other patents out there, not only from my licensor, but out in the marketplace, that, yeah, I get these patents from the University of Montana, but Monsanto has patents that cover portions of what I'm doing too. This doesn't give me the full right of what I need to go out and make the product. That kind of affects your licensing consideration as a licensee. We talked about confirming ownership already. Again, identifying those other rights and other associated IP rights and third-party patents and technology. It could also be identifying prior art and related documents that, yeah, these patents are issued, but they may have been invalid because I've seen prior art earlier than that. It wasn't raised. Just because they got an issued patent doesn't mean it can't be invalidated. So what other prior art out there may be right as I do my due diligence? How strong are these patents? And is there prior pending or threatened litigation already? I mean, they've already sued under these patents, or somebody's already tried to have these patents invalidated. You can look at the legal history of a patent when you're doing your analysis to determine what you need to do to kind of do that due diligence on the patents. When you draft the patent, you have to think about the scope of the grant. Are we capturing that correctly? Am I getting the territorial extent that I need? Am I getting rights worldwide or just in the United States? Can I do everything I want under the patent, or can I only manufacture it in the United States, or I can only manufacture it in Europe and sell here? You can carve up the rights any way you want to. There's a lot of flexibility in drafting patents, but you're going to need to consider what that looks like. Again, by way of both exclusivity and field of use. Do I have the rights to sub-license it? Which is, I'm the faculty startup, I'm going to develop this technology, it's going to be a component of my technology platform, and my eventual goal is to license this as a component with my other things to Glaxo. Can I do that? If I've got the license rights from the University of Montana, maybe I'm the one that's got to make and use and sell the product. Or do I need the rights to have somebody to make it for me? Or can I package the whole rights downstream to somebody else through a sub-license? Think about improvements. If I create improvements at my company and I'm the licensee from a university, do I own the improvements? Or do I have an obligation to assign the improvements back up to the university? What if the university comes up with improvements? Do I get that under the license? Or do I have to go back and negotiate a whole new license for the improvements? How's that going to work as we're working on improving and commercializing this technology and rolling it downfield? And obviously, when everyone always thinks, well, okay, how much is it going to cost me? What's the royalty terms? Am I doing usually you always see a running royalty. I get 5% of net sales of the product, and that gets kicked back up to the university. So however I sell this product, that's going to work. If you're the licensor, you have to think about, okay, 5% of net sales, that's fine. Well, what if my licensee sells it to their affiliate at cost, and the affiliate then sells it as a markup later on? What percentage of royalty do I get? Do I get the cost from my licensee to their, essentially their sister company at cost, and then they make the bigger sale down the road? What does that look like? So same thing with the sub-license. University decides, we want to encourage local development here in the state. It's our faculty member. We're going to give you a very reasonable royalty in this because we want you to start this company here, and we give you sub-licensing rights. And the next thing you do is you turn around and license it to Glaxo for big money. And the university says, whoa. If we wanted to license to Glaxo, we would just have done that ourselves for a different rate than what we're giving you, faculty startup. So think down the chain of commercialization. That'll affect the structure and how a license is put together. You have something called sort of reach-through licensing. And that's really kind of, what if I sell you a tool to do drug discovery? But I want my royalty to be on the drug that you discover with the tool, not on the tool. You're never going to sell the tool. I want royalties on the drug that you discover on my drug discovery tool that I'm licensing. In certain structures, you're able to set up a royalty agreement in that way. There's other legal pitfalls you need to do that, but you could set it up that way. Another one is a stacking provision. So if I'm paying the university, say, 5% of the net sales of my product, and I'm out there selling it 2-3 days, Glaxo comes knocking on my door and says, oh, by the way, the product you're selling, you also owe a 3% royalty to me on that because I've got patents covering it. You may want a provision that says, okay, if I have to do that, then I get to lower my royalty to the university by 3%. So I'm never paying more than 5% because that's how I've set up my commercialization. It can't go below a certain number. So if my royalties start stacking, I need royalty adjustments to bring that down. Sometimes you'll see negotiation around that point to try to plan for that contingency. Obviously, if you're a licensor, you generally don't like that. If you're a licensee, that's exactly what you want to give you that certainty. Obviously, you're going to need to have provisions to monitor and audit your license activity. If I'm the licensor and I say you owe me 5% of net sales and you just report every quarter, how do I know that report's accurate if I don't have the right to come in and do an audit to make sure that you're reporting everything correctly? If you have an exclusive license, so you're going to give all my rights in this field to my faculty startup, you're going to do everything you want. Well, let's say it's for the term of the patent, for the next 20 years. If you don't do anything with it, that technology is just shelved. It's just sitting on a shelf. So how do I get those rights back? Usually that's by way of making your licensees meet certain minimums. Either they have to develop, they have to sell a certain amount, they have to do something to move the technology forward. And if they don't meet those minimums, you can terminate the license and either take the license back or terminate the exclusivity so you can find another partner as well. So usually you're looking for a licensee, universities certainly are, as a faculty startup. They're going to ask, what's your commercialization plan? How are you going to develop it? What are your milestones going to look like, both commercially and development, and put those in place in a license. You'll need to discuss who's going to take care of the patent, who's going to pay for the patent. Usually university licensor entities want their companies now to pay for patent prosecution. So you're going to take the commercial value of this. We, the university, are going to prosecute the application. We're going to go to our attorneys, have it prosecuted. We're going to get an invoice. We're going to send it to you. You're going to pay it licensing. And then the licensee said, well, maybe that's fine, but maybe I want to pick counsel, and maybe I want to help drive prosecution. And you can kind of negotiate the balance of that. Infringement and enforcement. You get to talk about, well, if there's an infringer out there, who gets to sue? Is it the licensor or the licensee? Generally, the patent owner always has a right to sue. If they exclusively license it to a licensee, but it's still limited by a field of use, I give you all the rights to sue in the field of use for sales in the agriculture industry, this technology. And we'll give you the right to sue licensee. Licensee could say, hey, I'm an exclusive licensee. Monsanto's infringing my patent. I'm going to file suit against Monsanto. The court may say, that's great that you're the licensee, but you're not the owner. And you don't have exclusive license to all the rights. Therefore, if you want to sue, the owner's got to join the suit. So you better think about that when you're putting together the license, which is, if I'm an exclusive licensee and I don't have all the rights, the owner has to join my lawsuit. They have to agree to join my lawsuit. And sometimes the university says, you know what? I want to sue Monsanto. I want nothing to do with that because they're licensees on another field. So you may not be able to get them to join. So you need to think about, often that's negotiated in the license agreement, which is, how is an infringement going to work? Can you get the licensor to join? Do you need the licensor to join? If you're the licensor, do I really want the licensee to sue by themselves, or do I want to be able to sue first? And maybe I decide if I don't want to sue, then I'll let them sue and I'll join. And then who pays for that? And if there's a benefit, who gets the benefit at the end of the suit? Sometimes you'll often see the concept of the university will say, you know what, this is our patents. At the end of the day, we're a state institution. We're never going to be contractually obligated to sue somebody. We may choose to, but we may choose not to, and we're never going to agree that we're going to sue outright. Sometimes you'll say, that's fine, university, we're your licensee. But if you decide not to sue under certain circumstances, then you got to lower my royalty rate because I'm not getting my exclusivity. So sometimes you'll see that if your licensor just says, we're going to be in charge of enforcement, but we may or may not decide not to enforce the patent. Usually you're going to manage risk in a patent application. You're going to have standard reps and warranties. If you're a licensee, you want to make sure your licensor reps and warrants, they own the patents. They've got everything they need. Maybe you can even get them to rep and warranty that the patents are valid. You may even get them to rep and warranty that as far as they know, it doesn't, selling the product won't infringe anybody else's rights. You may get disclaimers of liability on behalf of the university saying, look, this is nascent technology. We're not saying it's going to work. We're not saying it's going to be valid. You're kind of taking it as is. You can limit your liability. You can put in indemnification clauses. Oftentimes the university says, look, you make a product, that's on you. If there's a defect in the product, somebody comes back and sues us, you licensee have to indemnify us. So a lot of times licensees will ask for indemnification from their licensors saying, look, if all we do is follow your patent and do it exactly the way you tell us to do and somebody comes and sues us, we want you to indemnify us for that as well. So it's kind of a risk mitigation for both parties need to kind of consider that as they go through. Same thing with insurance requirements. Even if you have indemnification, just because you say you're going to pay somebody doesn't mean you have the wherewithal to do so. Do you have certain amounts of insurance to kind of protect the indemnity provision in the agreement? What does the term look like? Is it for the life of the whole patent, or are there other terms on the agreement as well? If you're licensing hybrid intellectual property, both patents and trademarks, and you have, or excuse me, either patents and trademarks or patent and know-how, which sometimes you see, I'm licensing you my patents plus my trade secrets. It'll be for 40 years because the trade secrets go on forever, and you're going to pay me a 5% royalty. Well, what happens when the patents expire? Now they're still paying a 5% royalty. They're not getting patent license anymore. Patents are 20 years have gone. I'm still paying 5%. I'm still getting trade secrets. U.S. Supreme Court recently reaffirmed an older rule that says you can't do that. Once the patents expire, if you're licensing two rights, you have to adjust the royalty payment. So when you're thinking about terms and royalty obligations, you have to think about what's the effect of the termination of the license, what's the effect of the termination of the patents if the license goes beyond the life of the patents. And then what happens if I'm the licensee and I lose my license? Does my rights stop immediately? If I've got a warehouse full of product, am I allowed to sell that off after the agreement terminates for a certain period of time? Do I have to destroy all my product? What if I go bankrupt? Does the licensor get their license back? What if my licensor goes bankrupt? Not a huge concern if your licensor is a university, but certainly business to business it is. What does that look like? If I'm sub-licensing rights, what happens if I lose my license? Do my sub-licensees lose their license? How do we kind of deal with that in the license agreement? And what provisions survive? What does assignment look like? What if I want my business to be acquired? I'm a startup. I've got this license from the university, and Monsanto wants to buy me. Can I do that under the agreement? Well, it kind of depends what's in your license. Sometimes you can. Sometimes you're restricted from doing that because the university could say, look, I'm giving you, faculty startup, the sweetheart deal. Monsanto wants to buy you. We're going to have different financial terms on that. So I'm going to put a provision in the agreement saying you can't have a change of control or assign this license. And I get the right to either bless it or say no or terminate it. And so you have to think through those issues, especially as a new startup, of what is my transition plan? If I've got a buyout, if I've got an exit event that I'm planning for, does my license contemplate that? Are the things I'm going to need to contemplate when I go through my exit event to maintain this license? I realized that was a forced march because I had to stop kind of halfway through and start, so I apologize for glossing over things very, very quickly. Questions?
Sorry, I didn't quite catch that.
I have a question. So as university faculty, I have access to, let's say, a transgenic mouse that they will give to me and say, great, you're university faculty, you can do research, but not for commercial purposes. In the course of my research, I come up with an invention and file a patent. That obviously, then the university licenses. Does that person who originally gave that technology or strain to the university said you can't commercialize it, have any legal, is there any legal fallout from that?
You're going to love when attorneys say maybe. Everyone loves that. And the answer is maybe. There's a lot of things that kind of go into that. So they, it depends on, so they give you not for commercial purposes your use of that thing. Generally speaking, if you have it's unusual that you get it by way of what, an institutional?
From another university.
From another university.
Where they would sell it to a company, they'll give it to another university at no cost.
Generally, in those situations, you may be prohibited from filing something if it's tightly controlled on that. Usually, you get these under what's called material transfer agreements usually. And your material transfer agreement, either institutionally or, I know I've done a lot of these on behalf of my public companies that I do work for, that provide reagents and things they're working to universities, either at cost or for free to work in a lab because they want to see if things work. And they do these MTAs, and you can only use it for this purpose. It's not commercial. And sometimes those agreements will say, well, if you use it for that purpose and you actually do file something, we, company or person that provided the material, will now own that. And now you have a contractual obligation, your institution does, to abide by that. So even if you're the faculty member that came up with it, there's a restriction up the chain saying that I got a luciferase, and I use this luciferase in a way I wasn't supposed to. And the MTA said, if I use this luciferase or modify it in such a way other than for research and you file something on it, we, the company that gave you the luciferase, own it. And you went off and you filed your own patent. That company could come to the university and get the ownership rights of that back and sue because they violated the MTA. So it's fact specific, but yes, you have to be careful of restrictions like that. There's also restrictions if your invention was developed under federal funds, under an NIH grant. Now you have obligations to the funding agency under Bayh-Dole. The institution can still claim ownership, but they've got to jump through a bunch of hoops and things, and their licensees have to do the same thing to be compliant with federal law if you use federal funds as part of the development of your technology at a university. Yes?
In one of your early slides, you defined inventorship as flowchart like conception, due diligence, and another word toward the end?
And reduction to practice.
Reduction
To be an inventor, you need to conceive of the concept of it. That's all you need to do. To prove inventorship in a dispute, that you were the first one to invent, you have to prove conception, diligence, and reduction to practice to show that you were the first one to invent in an inventorship dispute. Again, it's pre-2013, so it's not going to be as relevant as it was, 3-4 years ago.
So my question about it is, most of us here work in a collaborative environment, and just by definition, collaboration is an exchange of ideas. So if you're in something like a meeting and you come up with an idea, how do you protect yourself as an inventor, when anybody has access to that in a meeting setting or somewhere else?
And that's usually that's why, even though the interference has gone away, the lab notebooks and everything else still come into play, which is who was the person that came up with the concept of the invention, the concept, the idea that we're trying to claim. This is my concept. And it's more than just recognition of a problem is usually concept of the invention. It's recognition of the problem and a potential solution. And you may have, say you're working with, I'm the faculty member, I've got this concept, I've got the idea, I think this is the invention, and I tell my grad student, well, go run this experiment and let's see if my concept proves out. The grad student that runs the experiment, that doesn't make him an inventor, even though he did the experiment. It was the conceptual aspect of it that led to it. Now, if the grad student comes up with a concept and the faculty member says, oh, that's right, that's a good idea. Doesn't make him the inventor either. It's the person that came up with the concept. And sort of it's the evidentiary aspects of keeping those lab notebooks and keeping those notes kind of flesh that out. And that's usually what the thing your patent attorney will work through when you go through the claims. Okay, who was involved in the project? Now, who actually were people that were conceived of what we have here of the invention versus people that just kind of worked on the project? Because it's a legal determination. They have to be listed as an inventor.
I had another question too.
Yeah.
So we're all at the university, and I'm not sure if the Freedom of Information Act allows like citizens to go through university emails, but would it be considered a public disclosure if an inventor, like an idea, was sent through like email or Skype or Slack or through text or something like that? Like,
well, it depends. I mean, if it's internal within the organization, usually, and there's the expectation of privacy. That's, I mean, if you put it in something that's going to be, is going to be made public, the FOIA thing I wouldn't worry too much about, and sort of standard things within the department, I wouldn't worry about a public disclosure. If you send it outside the institution, that's a whole different ball of wax. So, I'm going to send this concept over to this institution over here. Now it's in the wind, it's public. If you're just kind of like coordinating with your own people working on the project within a university environment, those types of notes, that's not really generally going to be considered a public disclosure. Because we're still within the organization. I mean, you're all employed by the university. It's going internally. There's a certain amount of expectation of confidentiality. That's going to be fine. If you start emailing it to your colleagues at other institutions, now it's out of the bag, unless there's sort of an interinstitution agreement of how you're working on a project.
yeah, or an NDA in place.
Yeah, or an NDA in place.
So I know the other 11 institutions are online and they can text in questions. Heidi, can you hear us?
Yep. We have a question over here from New Mexico, if you're ready. They want a little bit more elaboration on what the difference is between a divisional patent and the continuation of a patent.
Sure. Generally, they're roughly the same thing as far as how they are. They're identical patent. It's the same disclosure. You're just refiling it and getting a date. The difference is the divisional comes up with when you file an application and the examiner thinks that you've got too many inventions in one application, they issue a specific office action called a restriction requirement. And that restriction requirement says, okay, I don't think you have one invention. I think you have 5 inventions. And here's what they are. Claims 1 through 5 is the concept, or is the matter, the stool. Claims 6 through 10 is the method of making the stool, and claims 11 through 15 are the methods of using the stool. Okay, here we have 3 inventions, pick one. So in that instance, if I get a restriction requirement, the examiner's already set forth what he thinks the different groups of inventions are. Now I can argue that with him just like everything else. I can say, no. They're really one, and there's ways you can do that to try to get them consolidated. But let's say the examiner maintains his position. As the examiner's already set those stacks, if I file what's called a formal divisional electing one of the other ones that the examiner's already identified, he's not going to go through another restriction requirement process. He's just going to take, okay, you elected group 2, there's a divisional, I'm just going to go off and run with that. It's really the same filing as a continuation. You refile the whole application, and now you're just going with a certain subset of claims. With a continuation versus divisional, you're doing the exact same thing, but instead of just electing that specific group that the examiner gave you the restriction requirement on, you're maybe refiling all the claims all over again. He can give you a new restriction requirement. Or I'm changing the claims, or you're doing something other than just electing that other group that the examiner identified in that restriction requirement. That's really the difference between the divisional and the continuation. The divisional is really a continuation type response to the restriction requirement that you get from the examiner, where you're just electing that other group that the examiner said was another invention and just paying the USPTO more money to now prosecute what they consider a second invention.
So quick question, follow-up.
Yeah.
On that refiling, are you always going to end up with the same patent agent, or could that be a technique to get a different agent that may have a more favorable statistic?
Well, you're never guaranteed to get the same patent examiner. Okay. Generally speaking, once the examiner has signed the case, you're going to get the same examiner on the divisionals and the continuations. But they quit, they get reassigned, they die, some of them are pretty old. You know, you just don't, there's no guarantee you'll get the same examiner, but generally speaking, you should get the same. If they're still employed at the USPTO and they haven't changed ARC units, you're going to get the same examiner because that's just efficiency. That's just how they assign cases. And so usually if you get an examiner you don't like, you're really kind of stuck with that examiner until you go to one of the other appeal processes. You can have a pre-appeal trial brief. So before you get to appeal, you can get to a pre-appeal council where different examiners look at it before you file the appeal. You can file appeal. You can do all this other extra stuff, which you don't need to jumble your mind with. Other than there are options, but generally you're going back to the same examiner over and over again. Any other questions?
Heidi, is that it?
That's it. Thank you, Jeffrey.
Thank you.
All right. I think we're done. So thanks, everybody.